Hello everyone, my name is Evelyn Marr and I am a partner and head of the investment management department at BSP. Welcome to this, our first in a series of podcasts on various matters arising in the investment management environment here in Luxembourg. Luxembourg is the largest fund centre in Europe and the second largest in the world, with give or take €5 trillion of assets under management. The National Risk Assessment of Money Laundering and Terrorist Financing, published by the Luxembourg Ministry of Justice in September last year, recognised that given the large and diverse nature of the investment sector in Luxembourg, the challenges in detecting instances of money laundering or terrorist financing are not to be underestimated. The inherent risks in this sector were assessed as being high, though the residual risk level was assessed as medium, given that it is a sector that has been covered by the EU AML framework for some time and there is a good awareness of the risks. It's a topic that is very close to the heart of the regulator, the CSSF, and it impacts all investment funds, regardless of form or asset class, as well as their managers. We recently hosted training on the AML regulation applicable to one type of fund manager, the smaller alternative investment fund manager that is not fully authorised by the CSSF but is registered with the CSSF. I am joined here today by my colleague Christoforos Soterio, who led that training and who is going to walk us through some of the AML rules and regulations that are applicable to such managers.
Hi Evelyn, thank you for having me.
Hi Chris, and you're very welcome. So Chris, kicking off, are registered AIFMs fully in scope of the AML regulations here in Luxembourg?
Registered AIFMs are in scope of the AML regulations in Luxembourg in similar manner that fully authorized AIFMs are. In Luxembourg, both the 4th and the 5th AML directives are fully transposed into national law, with the core legislation being the law of 12th of November 2004 on the fight against money laundering and terrorist financing. Registered AIFMs are also subject to the Luxembourg law of 13th of January 2019, which creates a register of beneficial owners, hence obliging registered AIFMs to declare the beneficial owners, meaning the natural persons who ultimately own or control the registered AIFM through direct or indirect ownership of a percentage of 25% plus one share of the shares or voting rights or ownership interest in the registered AIFM. Additionally, registered AIFMs are subject to the Grand Ducal regulation of 1st February 2010, providing details on certain provisions of the AML law, and the CSSF regulation number 1202 of the 14th December 2012 on the fight against money laundering and terrorist financing, which further complements the AML law.
What does being in scope mean in terms of governance? What type of governance, from an AML point of view, do these registered AIFMs have to have in place?
Well, in principle, the board of the registered AIFM oversees the internal organization and compliance with the AML rules and procedures. Particularly, the board of the registered AIFM approves the AML policies in place, controls and procedures, appoints a compliance officer who is in charge of the control of compliance with the anti-money laundering obligations, Responsable du Contrôle or RC, and the person responsible for ensuring that the anti-money laundering obligations are respected, the Responsable du Respect or RR. The board also reviews the annual compliance report and any ad hoc reporting from the RC, assesses the registered AIFM's risk-based approach towards existing and prospective investors of its funds under management, and it documents it in writing. The board also approves any outsourcing contracts relating to the fund's anti-money laundering tasks and obligations. Just to note on this point that despite outsourcing such functions, the registered AIFM always bears ultimate responsibility in case something goes wrong.
You mentioned the Responsable du Respect, the RR. What exactly does the RR have to do on an ongoing basis in this role?
Sure. The board of the registered AIFM needs to appoint a person responsible for ensuring that the professional obligations of the AIFM are respected, Responsable du Respect, as regards the fight against money laundering and terrorist financing. The RR could be the entire board of the registered AIFM as a collegial body or one of the members of the board. The RR must also have sufficient knowledge of the Luxembourg legal framework and can demonstrate this upon request if needed. Must have sound knowledge of the investments and distribution strategies of the fund at stake or managed by the AIFM and of the services offered by the AIFM. Must also be available without delay upon contact by the Luxembourg competent authorities but if the RR is a collegial body, at least one of the members must fulfill this requirement. As far as the RR's obligations are concerned, the RR validates the supervisory system responsible for detection of suspicious activities or transactions, receives and reviews annual and ad hoc reports from the RC, and submits to the CSSF on an annual basis a summary report of the compliance function prepared by the RC.
Okay, so we have the board, then we have the OR, and so finally, what does the RC do in this hierarchy of governance at the registered AIFM?
The RC is a person at an appropriate hierarchical level within the AIFM who is responsible for controlling compliance with the AIFM's anti-money laundering obligations, responsible to control. As far as the RC's eligibility requirements are concerned, these are the same as the appointment of the RR as mentioned before. For example, when it comes to sound knowledge of the applicable AML framework in Luxembourg, etc. However, only one person can be the RC, compared to the RR that can be the whole body of the AIFM as a collegial body. Regarding the RC's duties, the RC ensures that the AIFM and the fund fulfill all their obligations as regards to their anti-money laundering obligations pursuant to the AML law, prepares the AML policy of the AIFM, implements and ensures the realization of anti-money laundering training and awareness-raising program of the AIFM's personnel, is also considered as a designated contact person for the Luxembourg authorities in charge of anti-money laundering and is in charge of the transmission of any information or statement to these authorities. The RC is also involved in the authorization process for new business relationships, for example, when it comes to onboarding investors, and subjects existing compliance control to regular controls and verifications, and reports on writing on a regular basis to the RR and where appropriate to the board of the AIFM.
You've mentioned a few times AML policies. What type of policies have to be drawn up or have to be in place? What type of procedures have to be in place at the level of the registered AIFM?
The AIFM should have a document in place that will describe the applicable anti-money laundering policies and procedures of the AIFM. This document should be tailored to the AIFM's business operations and dependent on the initial risk assessment documented by the AIFM that will describe the applicable anti-money laundering policies and procedures of the AIFM. This document should be tailored to the AIFM's business operations and dependent on the initial risk assessment documented by the AIFM. In a nutshell, such policies and procedures need to include due diligence measures that the AIFM has to carry out towards intermediaries acting on behalf of the AIFM, such as any distributors, customers, which are in this case are the investors in the funds managed by the AIFM, and due diligence measures should also be applied to both existing and prospective investors in the funds managed by the AIFM. And due diligence measures should also be in place when it comes to other business relationships. For example, if there's any investment advisor to the fund. The policies should also include procedures when it comes to applying enhanced or simplified due diligence measures that can be carried out on investors, counterparts, or intermediaries. There should also be record-keeping requirements, escalation procedures when faced with politically exposed persons, and procedures when it comes to overseeing delegates, if there are any delegates to the AIFM.
Okay, thank you, Chris. That was all very interesting. I think we will leave it there for today. If any of our listeners are curious and want to find out more, please don't hesitate to reach out to either Chris or myself. You can find our contact details on our website, www.bsp.lu. Thank you for listening.